Please the Court, Macy Nelson on behalf of Petitioner, the Patuxent Riverkeeper, whose Chief Executive Officer is Fred Tutman. My client thanks the Court for granting certiorari in this important case. This case concerns, as we all know, the application of Maryland's new statute governing standing in certain environmental challenges. This is in the code at Section 5-204, the environmental article. Effective date was January 1, 2010. Prior to the adoption of this statute, for the last generation or so, we operated under a system where, for certain permits, such as this wetlands permit, you would seek a contested case hearing, and if granted, you would have a evidentiary hearing with witnesses, expert witnesses, and lay witnesses before an ALJ, administrative law judge at the Office of Administrative Hearing, who would make a proposed decision, refer the case back to the agency for a final decision, and then there would be judicial review. The standard there was the classical Benarski standard of agreement, which all of us have argued and read about many times. Leading up to the 2010, or during the 2009 legislative session, there was a discussion between certain members of the environmental community and industry, the Chamber of Commerce, and they came up with this new statute. And I think it's very clear. What they said was, let's eliminate. Industry said, eliminate the contested case proceeding. We think it's time consuming. We want to go straight to the court from the agency, and we will give you broader standing, federal standing, organizational standing. That was the deal that was struck, and we had the benefit of a detailed record regarding the legislative history. The Attorney General commented in a written submission, which is in this record. The restricted standards for standing in today significantly impede the ability of individual citizens and environmental organizations to use the courts to protect the environment and enforce environmental laws. This was his argument. Let's expand standing. Let the citizens participate more fully in this process. And he argued, the Attorney General argued in favor of this broader standing, and indeed it was adopted effective January 1, 2010. This case came along. We challenged it in the circuit court. This is a wetlands permit, a non-tidal wetlands permit concerning land in Prince George's County on the Capitol Beltway on the east side. It's the last big parcel of undeveloped land in the area. It's a huge development, but the issue in this case is not the whole development. It's a massive development. But the issue here is a wetlands permit because the developer sought to construct a road and a bridge over a headwater stream of the western branch. As they applied for through their engineers, a non-tidal wetlands permit seeking permission to permanently impact 3/4 of an acre of wetlands perpetually, 3/4 of an acre of permanent impacts. They sought permission to have perpetual impacts of almost 200 feet of the stream. Also, they sought other temporary impacts. But the record is...
The numerical aspects of it are important to the application and the issuance of the permit. Does it really boil down to the ability to have this box culvert under the road, the access road?
I'm sorry, I didn't understand the court's question. I beg your pardon.
Is the function of the permit they received really to allow them to have this box culvert under the access road?
Yes, sir, that's correct.
Okay.
I would answer it this way, that I think the Attorney General, Mr. Snyder, did a calculation, came up with 97% of all the impacts are related to the box culvert. So I think, if I understand your question, answer yes. And I'm getting ahead of myself here, but the core we're here on standing, I know. But the core element in the challenge was move the road to the west, and there will be no impacts on the stream, no impacts on the wetlands. That was the substantive point, but we're here on standing.
West meaning going closer to the Beltway, shall we say?
That's correct. Okay. But whether it's east or west makes a difference. The point is there was another, we argued, practicable alternative to avoid the impact on the wetland. That was our substantive point. Move the road over here, avoid the impact. But we didn't get to argue that because we lost on standing. But under the federal statute, under the new law that was adopted by our legislature, the statute expressly said, look, we're going to follow the federal case law, we're going to follow the federal law governing organizational standing, and you need to put up a member who has a stake in the controversy. And we put up David Linthicum, a cartographer with the State Department, masters in cartography, masters in geography, who's deeply committed to the Western Branch, lives on the Patuxent River, kayaks on the Patuxent River every other day, does work on the Western Branch during the course of the year, has made a map of the Western Branch, which he sells for profit. But here is a man who's deeply committed to preserving and protecting this watershed. He's become very well informed on what the adverse effects are on watersheds such as this, and we put him up as our member to defend our claim for standing. And the record will reveals that he mapped all the streams on this site. He's a skilled cartographer. He uses aerial satellite imagery. He mapped all the streams. He knows exactly where the impacts are. He knows where the bridge is. And we put him up as our member. His affidavit is in the, I'm sorry.
But the fact that he was a cartographer doesn't in and of itself give him standing, because there's lots of people who I guess, you know, do that. But what specifically, I mean, in terms of interest, what differentiates him from any other person who may enjoy the waterway?
All right, right.
Because if we take the cartographer aside, because you're not arguing that anyone who maps a waterway has standing, isn't that right?
That's correct. The reason I mentioned the cartography issue is for the economic part of this case, because that's part of his injury. I also mentioned it to try to bring home the point, which I think is a fair one, that here is a man who's a serious individual who understands this watershed, who knows it, who knows its tributaries, has paddled on significant portions of it, has seen what's happened to it, and he's deeply committed to it. And this is all relevant to the test, I believe, in the federal law, that does he have a reasonable fear or concern that the activity that he challenges will have an effect on this waterway. So that's why I offer that.
So I'm trying to discern, is it his knowledge base that differentiates him? Because I would expect that it's hard for me to conceive federally that knowledge base would be sufficient. I'm trying to differentiate. I'm trying to find that confluence that differentiates him in such a way that he, I guess it would be different from
anybody else.
Okay.
And that, I mean, except his knowledge, but is it so that if you're not knowledgeable, you don't, you know, but you have an economic interest?
I think I understand the Court's question. I would say this, that it's all relevant, I assert. But let's look at the facts. He lives on the Patuxent river downstream from the challenge activity.
How far?
9.25 miles is his house. I'll get the record reference. I mean, and he's within feet. I think he's 60 feet from the high tide mark on the river. He's there on the riverbank. He paddles upstream on his kayak. There's a lot of kayaking. So he's on the Patuxent River every other day, the record is clear. He paddles upstream into the Western Branch. The record is 5 times a year. And because the tributary narrows and decreases in size, the closest you can get is approximately 8.5 miles. So he paddles within 8.5 miles of the property at issue here. He works as a volunteer on these tributaries, clearing the waterways. He's there. He's in the field. If you read the case law, one of the elements is the factual question, does the person use the waterway? We say yes. He lives on it. He kayaks on it every other day. He paddles within 8.5 miles of it because you can't go any closer. Now, my adversaries argue, well, 8.5 miles is too far away. That's a legal question that we have to debate, of course. So he's there as a layperson. He's on the water. He's in the water, walking in the water, clearing brush up to his waist in the water. So that's factually his contact with the water. His knowledge of the watershed, I assert, goes to the question of whether he has a reasonable concern whether this challenge activity at the headwaters of this important tributary creates a threat of damage to the waterway downstream. And we say his knowledge is relevant. He's very informed. He knows the literature. He's highly educated. He understands it. And he says, yes, I am concerned that if you do this development at the headwaters, if you put this bridge, I think it's 4 lanes across. They emphasize the width of this headwater. Well, at the headwater, the Nile is small. But I look at the bridge. I think it's 4 lanes across. This is no trivial footbridge. This is a major, major bridge. He says, scientifically, there's evidence that if you do development at the headwaters of these streams, you're going to add nitrogen to the waterway. You're going to add nutrients to the waterway, organic material. You're going to add sediment to the waterway. We've all seen the classical photographs of the Susquehanna where there's mud all the way up at the headwaters in Troy, New York, coming all the way down to the middle of the bay. That's sediment. The same is true here on a smaller scale. He says that there's a risk. I'm sorry.
A certain amount of this is pretty fact-specific.
Yes, sir.
It strikes me that for purposes of standing, we have the cases that say, a mere interest doesn't get you there. But
right.
If it is, what's the right word, if there's a potential effect on recreational or aesthetic or economic interests,
correct,
you got it.
You got it.
Here it seems that the circuit court, after quoting those cases, then got into the specifics of what Mr. Linthicum has done and hasn't done, and then says his concerns are conjectural. Well, that strikes me as beyond standing at that point. We really are here on the issue of standing, so tell us why he does have federal standing under, what is it, the Ladlow case? Regardless of his particular interest and expertise.
Yes, Your Honor. First of all, please let me start with this fundamental premise. If you read the case law, many of the cases, environmental case law, are cases where someone is seeking to go into court, federal court, to seek penalties for the historical illegal discharges, historical events. Our case is a prospective permit where someone has come in and the applicant has asked for permission to impose permanent impacts on the natural resource, and we're trying to stop that on the theory that there's going to be harm in the future. So this is a permit that was just issued. This is not like the Laidlaw case where it's been going on for 10 or 15 years. It's not like the Simpkins case where you have 5 years of discharge. It's looking into the future and making a judgment as to whether someone has a reasonable fear and concern whether this permit, which we say was illegally and wrongfully issued, will create a threat of injury to this waterway.
Well, I live 7 miles from the Mason-Dixon line.
Yes, sir.
I think we would agree I would not have standing to challenge this permit. Mr. Linthicum is closer, but what gives him the standing that a Baltimore County resident wouldn't have, say, to challenge this?
Well, no Baltimore County resident is downstream of this property. No Baltimore County resident has land on the western branch. No Baltimore County resident owns land bordering the Patuxent River. Now,
What's the best case in your quiver for standing for somebody geographically located the distance that Mr. Linthicum is?
Laidlaw, 40 miles. Gaston, Laidlaw, Norman Sharp in the Laidlaw case. It just spells it out in black and white, where district court found for the plaintiff, appealed to the Fourth Circuit reversed, no standing, went up to the Supreme Court, and this is where the Supreme Court held categorically, look, you don't have to prove harm to the natural resource to have standing.
The circuit court actually quotes a little bit of the case, but doesn't, on the final page, analyze that. The circuit court sort of shifts to the conjecture, to use the court's term, and I don't know that that's the real standing test.
Which? I'm sorry.
The one that appears in the final full paragraph of the circuit court's opinion.
No, I think the court missed the boat. That's why we're here. But just to finish my question about the best case of my quiver, it's Laidlaw, where they talk about, they go through each of the individuals by name, talking about where that person lives, how close to the source, and then they go, and then we quote, and this is powerful, powerful stuff for our side, and then they get to Norman Sharp, who's 40 canoes, doesn't even own land, canoes 40 miles downstream. Each of the plaintiffs, the court holds, meets the test for injury in fact or legal injury to get you into court. But the real, what Laidlaw teaches us is you don't have to prove harm. The question is whether you have a reasonable fear and concern that the affected, the permitted activity will have an effect on the waterway. And
Mr. Nelson, just for a moment, Laidlaw, my notes suggest that the members of that organization swam, hiked, and fished 3 to 15 miles downstream from the facility. Am I?
I don't wish to.
Well, some of them did.
Some of them did. You're partly correct, but I would, if you want, I can pull it out. If you just read, follow on. There's 2 pages where they go through each of the plaintiffs. And since we're there, I'll just talk right here. Here's Laidlaw.
And the court held that they all did, even the ones who were 40 miles distant?
Well, I would direct the answer to Your Honor's question is yes. And I'm looking at page 182 and 183. They talk about Ms. Patterson. They talk about Ms. Moore. Then they turn to Norman Sharp at page 83. Sierra Club member Norman Sharp averred that he had canoed approximately 40 miles downstream of the facility and would like to canoe closer to the discharge point, but didn't do so because of concern about the discharge. New paragraph, these sworn statements adequately documented injury in fact.
Now, do we have an analogous statement here that our member did not go closer because he was concerned about the discharge or about the effects of
No, that's not in this record. That's why I opened my remarks by talking about this is a prospective permit as distinct from attacking historical illegal discharges. We're trying to stop. In theory, we could have had this hearing in the circuit court 5 minutes after the issuance of the permit before they built the facility, you see. So we're talking about, or in fact, our argument, I think, was 7 months after, but there was nothing. The harm is going to be in the future. That's why I just try to distinguish our case from historical discharges.
I see. Okay.
Are you getting ready to get into your rebuttal?
Then I'll save it. Appreciate the court's questions, and thank you for the reminder about the time.
Thank you. Mr. Gibbs.
Good afternoon, Your Honor, members of the Court, and may it please the Court. Edward Gibbs here on behalf of Petrie ELG Inglewood Limited Liability Company, the owner and the developer and the builder of the commercial component of this project at Woodmore Town Center at Glen Arden. Let me start by saying that, we are here on the issue of standing and how the new standing law in Maryland is going to be applied. My client, as I mentioned, is in fact the developer of the commercial component at Woodmore Town Center. I think a couple of factual points I'd like to make before I get into the issue of the legal arguments is, number one, that the culvert that we installed pursuant to a permit issued by MDE, which it took us 3 years of review to get. We filed it in April of 2007. We got it in March of 2010. Authorized the installation of a 4-cell box culvert. Each cell is 10 feet wide. The 2 inner chambers are 6 feet wide. They are submerged 1 foot in the center of the stream. Now, bear in mind, the stream is less than 3 feet wide and no greater than 4 inches deep after a rain event. I cite you to Appendix 11.
Well, that's getting into the merits of it again, and I don't know, maybe these cases are such that you got to get into the merits a little bit on the standing issue. But why doesn't everybody downstream have standing for purposes of challenging the permit?
Well, the federal standard, when the law was amended by the General Assembly during the 2009 session, the new law which resulted was a compromise position, and it adopted the federal standing requirements, and it said that to challenge a permit of this nature, a petitioner, a plaintiff, had to conform to the threshold federal standard requirements. The threshold federal standard requirements are, as a plaintiff in an action, if your standing is challenged, you have the obligation of establishing that you have sustained an injury in fact, which is concrete and particularized.
Well, how do you do it if the injury is if the potential injury event has not occurred yet?
That's exactly their problem, Your Honor, because
so they have to wait until
it's all built? No, if you are going to assert a future harm,
yes,
the federal test requires you to prove that that future harm is imminent to you. And in each of these,
which case?
Pardon me?
Which case are you relying on for imminence?
That test is set forth in detail in both Lewin v. Defenders of the Wildlife, as well as in Laidlaw. And
I'll find it. Don't worry.
It says on page 180 of the Supreme Court decision, to satisfy Article 3 standing requirement, a plaintiff must show, 1, it has suffered an injury in fact that is A, concrete and particularized, and B, actual or imminent, not conjectural or hypothetical, and that the injury is fairly traceable to the action of the defendant. So in this case, it was
What case were you reading from?
This is Laidlaw at page 180.
That was when the discharge was already there.
The discharge was already there, but the test.
So the discharge is already there. So you.
That's
when
correct.
You're dealing with one that's potential. It's almost certainly has to be to some extent conjectural, doesn't it?
No, well, Your Honor, I would submit to the Court that in Laidlaw there were discharges of pollutants that were occurring into the river. However, when a challenge was lodged to standing in Laidlaw, initially the defendant said they haven't proven a harm to the environment, and the Court said no, the harm that you prove is to the plaintiff, not to the environment. And what the Court said was you don't have to prove that these discharges have harmed the river. You have to prove that their perceptions of harm are reasonable and imminent. And so, viewing the facts of that case, the Court said, all right, we have someone who is 3/4 of a mile that lives from the plant, and she would have used the river but now she is less likely to because of the pollutants. There's a person who lived about a half mile away who drove over the river and said, it looks polluted, it smells polluted, I won't fish in it, I'd like to, but I won't. Those are reasonable concerns about an imminent event that's going to harm them in the future.
But if there is concern that the proposed changing of the waterway will have an effect on how things flow, which in turn will have an effect on what grows there and what doesn't.
But a concern, again, all of the cases are legion in the Supreme Court in stating that the concern has to be reasonable. You can't just say, because there's a permit here that allows
So
someone...
you're moving away from imminent and now going to reasonable.
That is also one of the requirements.
Well, didn't the internally, didn't the Maryland Department express concerns by its biologists that there would be a change?
In this case?
Yeah.
No, Your Honor, not to my knowledge.
All right, I'll go back and check my
Yeah.
facts.
Is there anything in the legislative record when this was done in Maryland that attempted to compare and contrast the differences between the law as it developed under the aggrievement standard and the federal standard, so one could see in some analytical way, whether it be a side-by-side comparison or any other expository way? What's the difference between the two?
Well, the old law that we had was obviously the standard aggrievement test for a permit of this nature, where you would say, all right, am I in sight and sound? And an organization would have extreme difficulty because you have to show that you as the plaintiff were affected in some way different than anyone else in order to be aggrieved by the action you were complaining of. Under the federal standard, you have to show an organization can claim standing through its members if one of its members is injured, but then you have to show that you have sustained an injury in fact. It's a lower bar than what aggrievement was, but the bar was not dropped on the ground. There is still a standard. There's still a hurdle which needs to be overcome before the case can be considered on its merits by the court.
Did you find any scholarly research? I see that the MDE cites to the Tulane Law Review article. Anybody find any other law review articles discussing? The Tulane article talked about Laid law particularly, but
right.
Discussing the federal standard, its application, and or any comparison to local standards that pre-existed, perhaps?
No, Your Honor. I didn't find any of that nature, and this change in the law is of such recent vintage that I'm not sure that any would exist over the course of the last year. But certainly, if they are, I'm not aware of them. But to get back, we have, the Patuxent Riverkeeper offered one person in this case by which they would attempt to establish standing. They proposed that they would show injury in fact through Mr. David Linthicum. Mr. Linthicum came forward. He ultimately submitted an affidavit, and he ultimately testified in court on November 3rd of 2010. His testimony spans about 100 pages of transcript. He was questioned about his affidavit, and he was questioned about his knowledge. Now, here's a man who has to show that he has been injured in fact by virtue of this permit. All right? The impact of this permit, there is not a shred of evidence in the record that would support a conclusion that this permit has any impact beyond the 4 squares of the culvert area. There is nothing in the record to that effect.
In showing injury for the purposes of standing, how in-depth does a wannabe plaintiff have to be? I mean, allegations, you're saying allegations are not sufficient?
I'm saying, first of all, we originally filed a motion to dismiss. It was converted to a motion for summary judgment by virtue of the fact that testimony was taken in court. Evidence outside the record was considered by the court in making the decision on standing. Okay. So the evidence which was indeed the plaintiff's burden in this case. The evidence had to establish an injury in fact. I don't know that preponderance of the evidence is a standard that's been articulated for that.
Am I correct in thinking that at least one of the members of the plaintiff organization had cited to an article that would describe how there would be injury to the environment as a result of
Okay, yeah, and I was going to try and get to that. Yes.
So is that just, well, go ahead.
Yeah, we submit to the court that fell far short of getting them over the hurdle. Those articles, there were 3 articles that were quoted from Mr. Linthicum's affidavit. Each of those articles talked about the long-term adverse impact of urbanization and development in general. And everyone knows that over the course of a long period of time, development will have an impact. That falls far short of indicating that there was an impact as a result of this permit. That was his requirement. His burden was to show that this individual permit created an injury to him, not that this permit, along with 20 other years' worth of development, ultimately, at some point in the future, down the road, is going to cause injury to him.
Was that all he cited?
Pardon me?
Was that all he cited?
Your Honor, he quoted from 3 articles. He had a number of other articles as footnotes in his affidavit, and then he gave a huge amount of testimony. He testified that, first of all, he doesn't live 9 1/4 miles away. He lives 12 miles away.
Let's go back to the articles for a minute, though. Do the articles that he cited contain some expression of scientific opinion that when the pathway of the stream is modified, there's going to be a modification to the fauna that live there, and that is going to have an environmental impact that could be negative?
Right. Here's my understanding of what was in the articles, Your Honor. The articles talked about the overall impact that development has, the overall impact on wetlands that development has, not one individual impact. It also talked about how he had a quote from an article that said, a culvert, if it channelizes flow and creates a higher velocity, can then create erosion downstream and create a problem. He was cross-examined by me on that proffer, and I said, Mr. Linthicum, said, if you assume that that does not occur with this particular culvert, given the fact that we made it 40 feet wide, we didn't constrict the flow, if you assume that the reverse is true, does that mean that there is no injury downstream? He didn't want to answer the question. And ultimately, and I've cited that line of questioning in my brief, ultimately the court had to paraphrase the question for him, and he said, yeah, hypothetically that's true. If you don't increase the flow, you're not going to have damage downstream. Now, since this was a summary judgment motion, a representative of my client testified before the circuit court as well, and and this is why I was trying to get into the design of the chamber, Your Honor, because he testified that the 2 inner chambers, which were each 10 feet wide, were sunk a foot down into the soil and then compacted with clay so as to mimic the stream bed and to allow the water to meander as it would choose to. It did not create channelization. So
now, when you're talking about the summary judgment, are you departing from the standing issue?
No. It was a summary judgment motion on standing.
Oh, okay. I think of the standing issue as a motion to dismiss.
Right. Filed as a motion to dismiss, but when the court and both parties agree in the standard of review, when the court considers extrinsic evidence on the motion, it becomes a motion for summary judgment. But my point is this, Your Honor. In each and every instance when Mr. Linthicum was confronted during his testimony, do you have any knowledge of any facts which would support the comments that you're referring to in these articles? His answer was no. And he said,
well, it strikes me, if you said, I concede standing, let's proceed to the merits of this, it'd be over.
Well, Your Honor, to that, I would only say, as the Supreme Court said in the Valley Forge case, which has been cited by the petitioner here, is that that, you know, the restrictions that Article 3 place on the courts in terms of the cases and controversies that they can hear are absolutely as important to our Constitution as the authority that the courts give.
I don't disagree with that, but a lot of the argument we've heard here today is, you know, give me standing because there's merit to our position. Deny them standing because we've done it perfectly and there is no harm whatsoever. The standing issue is a little different, though. I mean, standing gets you up to the plate.
That's right.
Well,
It's more than an inconvenient hurdle, Your Honor. It's a requirement. And the reality of the matter is that in this case, Mr. Lincoln.
I don't know that whether the culvert is a foot down or 20 feet down makes any difference to the issue of standing.
Well, it does when he's depending on standing to say, I know there's going to be an impact downstream because you're channeling the water into the culvert and you're going to increase the flow and that's going to cause erosion and that's going to send sediment down to the western branch where I like
if he says I live a mile down the river and I'm concerned about that, it strikes me. He's got standing. He now proceed to the merits of the case, and if it is the way you say it is, and this has been done perfectly and there's no danger whatsoever, the court affirms.
Well,
we go on from there.
Obviously, with the utmost of respect to Your Honor, I don't think the facts of the case establish that he has, in fact, met his standing burden here. You know, he has to.
I'm not saying that standing has been established.
Mm-hmm.
I'm only saying that the fact that we presume the agency did everything right, the applicant did everything right, and there has been a demonstration that everything will be fine here, nobody really needs to worry, is dispositive of the standing issue.
Well, if you get past standing, then you do get to the merits. But, again, with the utmost of respect, Your Honor, I don't think the mere fact that the merits are strong should have us make a hasty or ill-informed decision relative to standing, or that my client should, for that matter, just overlook it when it doesn't exist. And
overlook what?
The fact that there is no standing. In other words, don't raise the standing issue and just go directly to the merits.
That's fine. You're certainly free to raise the standing issue, of course. But the extent to which the standing issue you want us to hold is controlled by the conduct that's already been done pursuant to the permit is putting the cart before the horse.
Well, I think that those were items that were appropriate to put before the court on the issue of standing. But let me just say this. Mr. Linthicum had to show that his enjoyment of the Western Branch, where he goes 5 times a year, 8.5 miles from this culvert, was adversely impacted by virtue of this culvert being installed.
Well, is that exactly right?
Yes.
Doesn't he merely have to show a reasonable fear that he will be affected by this?
It has to be a reasonable concern.
Okay.
Absolutely.
And isn't
reasonable.
there also language in, whether it's Laidlaw or maybe some of the other opinions on the subject, that only a trifle of evidence? I know I'm lifting language out of an
Well, it's funny you should mention that, Your Honor, because the identifiable trifle quote comes out of Duffer & Powell, which is a Federal Circuit Court of Appeals decision, but it's actually a quotation from United States versus Scrap, which is a 1973 Supreme Court case that the Supreme Court's really been backing up from for the last 38 years. And that quote appears in a footnote buried on page 689.
So you would say, forget that language.
Okay.
But you would agree, though, that he doesn't have to know. I think I heard in your answer to one of Judge Murphy's questions was he has to know that this is going to happen. Is that the test for standing?
He has to have his concern has to be reasonable, and the court must determine whether that concern is reasonable from looking at all the facts and circumstances of the case. And in this case, Mr. Linthicum testified that he had paddled on the Western Branch 7 months after the work had been done, and he could see no impact whatsoever. His pleasure, his enjoyment, but his quality of life, everything he did on the Western Branch was not impacted in any way. So that bears upon, and to me, augurs in favor of a conclusion that Mr. Linthicum's enjoyment wasn't impacted, and his concern that he registers is not objectively legitimate. There's no question that he's an avid environmentalist and that he cares about the Western Branch. That's far different than saying that his enjoyment of the Western Branch has been damaged as a result of this permit. There's just no evidence to that effect.
At the time the judicial review action was filed, had the work been completed?
Finished. Thank you.
Mr. Snyder?
Thank you. Good afternoon.
I'm curious, what happened to MDE from the time it opposed the standing of Patuxent Riverkeeper and Mr. Linthicum to its ambivalence before this court?
What happened is that this court took this case, and cases that are before this court.
It scared you out of your conviction?
No, it's that this court is set to set the stage for standing principles in the foreseeable future. The stakes are higher here. The perspective is different than a case that's before the circuit court. It is not uncommon as a case moves up through the appellate courts for the state to look at it and look at it again as its perspective changes. And in this case, we're talking about standing principles that reach well beyond the facts of this case, that reach beyond the Department of the Environment and implicate the Department of Natural Resources and the Board of Public Works as well, and that implicate the state's rights as well, because the state, while typically aligned with defendants and standing issues when citizens sue the state over the conduct of its duties, it sometimes finds itself with a need to exercise its rights under federal environmental statutes to bring citizen suits to protect Marylanders' rights and health and the environment. And so it's kind of on both sides of this issue. Sometimes it'll be cast in the role of the plaintiff, sometimes cast in the role of the defendant. So the state, writ large, does not have an interest in the outcome of this particular case. It stands ready to defend the merits of the permit decision. But it does have an interest in the explication of the law and on kind of the true and narrow course. So that's why we're not taking a position on the facts of this case, not arguing about how the standard should be applied to the unique facts of this case, but instead presented the brief and are here today to discuss the standard in general. Now, I know you all have had a lot of questions, and so I'm here primarily to answer your questions, but I want to...
To what extent, in order to resolve the standing issue, should the court, in these judicial review actions, get into the facts of the case and the, let's say, the strengths and the weaknesses of the competing arguments?
Judge Murphy, as you said earlier in your remarks, it's almost inevitable that you have to get into the merits a little bit. But the case law is fairly clear that you have to avoid having mini trials with a battle of the experts to determine whether a party even has standing to get into court. One aspect about this wetlands permit is, as counsel mentioned in his opening remarks, the merits is about a practicable alternatives analysis, whether the bridge should be here or whether the bridge should be there. It's not really going to be focused on whether any sediment is going to leave the site and make it down to where Mr. Linthicum uses the river. It's a different issue. But your point is still well taken. The point of standing is not to require people to have a mini trial in order just to get into court.
I mean, it seems to me the circuit court shouldn't say to the next door neighbor, you don't have standing to contest this because I'm satisfied on the merits. Everything was done right here and you're all wet.
You're correct. That's not the way to go.
On the other hand, where the concern expressed by the person who might or might not have standing involves aesthetics, should the court, under those circumstances, look to the factual history of the process and any evidence that's been presented on the issue of whether there is any bona fides to the claim I'm concerned about the aesthetic effect of this thing?
I think it depends on how much information the litigant actually provides. So if someone alleges a lot of evidence supporting their claim to standing, the court, of course, can consider that in whether it does or does not support standing. And people, would-be litigants who go through this permitting process can establish their standing through their comments to the Department of the Environment by describing.
Does that involve a credibility assessment of any kind?
It involves a credibility assessment not in the traditional trial court setting, but the federal case law, when they're talking about this reasonable fear, they also talk about a credible fear. And to some extent, it really comes down to just the trial court looking at this and saying, is this enough? Is it reasonable for this gentleman to be concerned that 8.5 miles downstream he'll be affected by this culvert? And that's really what it comes down to in these forward-looking cases, rather than cases like Gaston Copper and Laidlaw, where you're going to have some objective evidence of pollution in the waterway that can establish, corroborate the reasonable fears.
So necessarily in these kinds of cases, there's going to be a certain amount of conjecture.
Some amount of yes, conjecture, speculation.
Whatever you want to
yes.
call it.
Yes, and the question is whether that speculation is reasonable under the circumstance.
How do you determine reasonableness? That's the question.
Well, that is the question, and I don't have an easy answer for you, because it is going to be determined, like most reasonableness determinations, just based on the evidence before you, which will change over time. Because
see, that's where you get into a problem, because if in fact reasonableness really does go to the merits, then you do end up necessarily involving yourself in a mini-trial on the merits.
well, there can be cases in which the injury to the plaintiff would overlap significantly with the merits. That's not the case in this type of permit, where the merits is really going to come down to, should the bridge have been put there or should the bridge have been put over there?
Yeah, but see, the way this one resolved itself, as I understand it, he says, I'm concerned about X. The response is, that's no reason to be concerned, because, to the merits, we've done thus and so. That's then presented, and no standing. Is that the way it should be done? Because there, you know, there is an intertwining of the merits with the standing issue, to the extent that the merits really do supersede the standing, right?
Yes, if we're talking about merits with a small m. I mean, the substance of the matter. Yes.
Yeah, that's exactly what I'm talking about.
And yes, you're right. In all of these cases like Gaston Copper and Laidlaw, you don't have to get into that merit so much because it's laid out for you.
Statements of historical fact.
Right.
There was a reference earlier about stuff coming down the Susquehanna River. If your shop granted a permit to somebody up in Port Deposit, and now we've got somebody on Ken Island squawking about it, the one on Ken Island could probably make the case, I've got standing. I'm very concerned about stuff coming out of the Susquehanna River. It's coming right down the bay. And we'd give standing to that person.
Well, that would butt up against the principle, and I see I've run out of time. I'd like to just respond.
Not yet. You got a minute.
Oh, okay. I don't appear before you often enough to know that. It butts up against the principle in the Crown Central case that you can't base standing simply on the truism that water flows downhill. You can't just say something is being released up there. I live way down here.
What else would a person on Ken Island have to do under those circumstances?
Well, they may not. When they're kind of pushing the envelope on distance, they may need to come in with more detail, more factual matter to develop their claim to standing. If they're living just 200 yards downstream, that would probably be enough.
Is, I guess, although you're neutral with respect to, I guess, this particular issue, you're saying to us, any opinion you write should recognize that for purposes of standing, some of the historical facts that would otherwise be for the trial on the merits are appropriate for consideration.
Yes.
Okay.
Because in this case where we've had some factual development before the trial court, that is relevant for you to consider. Thank you.
Thank you. Mr. Nelson.
Thank you, Judge Pellett. Judge Harrell, you asked if anyone had made a chart comparing the state and federal.
I was just trying to get a handle on whether the legislature knew what it was doing.
Oh, I'll dodge that question and do a chart. I don't think they knew what they were doing, to be frank. But I did a chart. In the state system, you have to show actual harm. The language in the urban setting, we see within sight and sound, agreement. That's the Benarski case. In the federal arena, and this judge identifiable trifle makes it. State court, no way. In the federal arena, not onerous. I don't think those are not words we would use when we're talking about the Benarski standard. In the federal system, in the Simpkins case from 1988, Fourth Circuit case coming out of Baltimore, the discharger, this is a historical case, failed to maintain the records. So there's a total absence of information, and the absence of information was an injury, in fact, because you don't know what they discharged. That wouldn't cut it, I suggest, in the state court agreement standing. In the federal arena, the lessening of an aesthetic value is sufficient for standing. In the state court arena, I suggest.
But it's got to be something more than I think that it's going to be bad.
Oh, I think so. Absolutely.
How much more?
Well, using the language of the courts, I think that there has to be a reasonable concern that there's a threat of some harm, even an identifiable trifle of harm, to the water I use.
What about the fact that, and tell me if you think it informs this question, that Mr. Linthicum testified on cross-examination, admitted on cross-examination that to date he had not discerned any ill effects. Does that inform his reasonable concern? I don't know if Judge Lamazzi referred to it or not. I don't recall from my review of her.
I was asked whether he said that. He did say that. It's a fact. But I say no. I mean, environmental harm is done over time, not in weeks, days, or 7 months. No.
But death by 1,000 cuts or something like that.
That was the language, and I think that meets the test under the federal
Was there
jurisdiction.
any evidence that this could be seasonal, water change? I don't.
No, I think
In the
language,
spring there's more rain, or at least there has been this spring?
I think the reason what the court saw there was that I've seen changes in the season, but he said I don't attribute that to this bridge.
And his concern was sediment?
Sediment, nitrogen, nutrients, phosphates, flow, fish migration, all of which is in the record, not just sediments.
How's that going to – this was an unnamed tributary that was originally, 3-4 feet wide?
Yes, sir.
For the construction?
Yes, sir.
I understand sediment. I understand erosion. How does the construction project of the culvert generate nitrogen?
We're going to
maybe the associated project.
No, I would say this. The evidence in this record is there's a loss, the permanent, perpetual loss of 3/4 of an acre of wetlands. And wetlands have a lot of important functions, one of which is really to act as a filter. Or
intercept and filter.
Yeah, and those are gone. And I think that if you read his affidavit, if you read the articles that he cited...
But the nitrogen has to come from something else.
Oh, well, yes, that's a runoff. Yeah, but my point is the loss of the wetlands eliminates the filter to allow the nitrogen now to get into the stream. I think that's the point the witness... I know that's the point the witness was making. Judge Judge Atkins first asked a question about whether you had to prove with certainty for standing the scientific proposition. Then there was a series of questions, well, do we convert it to a mini-trial? And lay law addresses that issue head-on. The relevant showing, I'm quoting from the opinion now, the relevant showing for purposes of Article III standing, however, is not injury to the environment, but injury to the plaintiff. We all agree on that. To insist upon the former rather than the latter as part of the standing inquiry is to raise the standing hurdle higher than the necessary for showing for success on the merits. Because when we try the case on the merits, we don't have to prove harm 8 miles downstream. Mr. Snyder was correct. We're talking about were there practicable alternatives. So we're now, if we adopt the developer's perspective, we have a higher burden on standing than we do on the merits. And then in the Fourth Circuit, Gaston says at page 161, Gaston's after the laid law, it's discussion, if scientific certainty were the standard, then plaintiffs would be required to supply costly, strict proof of causation, even where the cause of action does not require it. And then the Gaston case, I would urge the Court, if the Court reads two cases, I would urge the Court to read laid law and Gaston. Gaston won 204 F. 3rd, because Gaston reviews all of the law. And there, the Fourth Circuit reversed the district court because the district court, it found, improperly required the plaintiffs to demonstrate that the chemical content of the waterway was affected by the facility. So there the district court said, plaintiff, you didn't prove that there's actual harm to your waterway, therefore we're going to throw you out on standing. And the Fourth Circuit said, no, that is not the law. And with all due respect to the circuit court in this case, that is precisely what the lower court did. And on behalf of my client, we urge this court to reverse. Judge Murphy, I think this is my last argument before you, sir. Thank you very much for all your guidance. I appreciate it. Thank you all.
I'll be around.
Your speech tomorrow.